Thank you. Can I, attention all committee members, can I welcome everyone to the Justice Committee's 24th meeting in 2013. Can I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when switched to silent. And I welcome Margaret Mitchell to the meeting as the new member of the committee. Margaret, you're very welcome. Item 1, declaration of interest, and that's to invite Margaret to declare any interest relevant to this committee. 3 minutes.
No relevant interest to declare, Convener.
Thank you. Item 2, I'm inviting you to agree to take items 5 and 6 in private. Item 5 is consideration of a draft report, and item 6 is consideration of correspondence and the committee's engagement strategy. Are you agreed that we take these items in private? That's items 5 and 6. Agreed. Thank you very much. Next week, we'll be considering our approach to budget scrutiny. Logically, it may be better to take this item first, and so I'm asking the committee again to take this decision to give us flexibility to be able to begin next week in private session to assist with the timetable. This is just to consider a budget scrutiny approach. Right. This is because Lord Calloway will be giving evidence from 11 AM, so it lets us fit that in. Right. Item 3, Tribunals Scotland Bill. This is the second evidence session on that bill, and we have 2 panels giving evidence today. And I welcome to meeting the first panel, Right Honourable Lord Gill, Lord President of the Court of Session, holder of a season ticket now almost to the Justice Committee, for good or bad, Chris Nicholson, Deputy Legal Secretary to the Lord President, and Innes Fife, Head of Strategy and Governance, Judicial Officer Scotland. Can I thank you, Lord Gill, for your written submission? Now, straight to questions from members, please. You're not ready. John.
Thank you, Convener. Good morning, panel. Lord Gill, a lot of the representations we've had have been about experience and the experience that's been gained over the in the individual tribunals. Are you able to comment how issues like, if you like, service continuity or succession planning are dealt with ordinarily, never mind any changes, so that, I mean, people seem to invest a lot of kudos in folk having experience, having been on the individual tribunals?
Well, at the moment, I think the arrangements are pretty haphazard. You know, there are differences between various tribunals in relation to recruitment and training. One of the big opportunities here is that the Scottish Judicial Institute for Scotland will be involved in the training of tribunals, which will introduce a degree of uniformity in terms of training and knowledge and experience. But the key to all of the tribunals, the key to the success of them, is that they have non-legal members who have relevant experience in the particular work of the tribunal. Employment tribunal is, I suppose, the best example I could give you, where you have representatives of both sides of the employment contract as members of the tribunal.
I'm sure whilst there's generic skills, again, they'd be concerned that that uniformity of training would somehow dilute the expertise. How would you address that concern?
I don't think so. I think that the recruitment process, which will also fall into the remit of the Judicial Appointments Board, the recruitment process will ensure that people with relevant experience are recruited to these specialist tribunals.
Do you have any concerns at all about, if you like, slippage, loss of experience as a result of changes?
I don't think so, no. And certainly there's no particular point being drawn to my attention in relation to that.
Okay, thank you very much indeed.
Thank you, John. I'll take, if you don't mind, I'll take Margaret. This is her inaugural meeting. So, Margaret, there you go. And then I've got Colin, Roderick, Elaine and Sandra.
Good morning. A number of the proposals contained in the bill are aimed at ensuring increasing independence for the judiciary. However, Lord President, in your evidence you say the bill is an important step, but you suggest that to achieve independence of the judiciary to be guaranteed, then further reform would be needed. Could you elaborate on that, and could this further reform not be contained in the bill?
Well, there is a statutory commitment in the bill which I welcome, which acknowledges that the tribunals are independent and judicial. But in the Judiciary and Courts Act, which the 2008 Act, which really governs the judiciary in the Court of Session and in the Sheriff Court, there is overall judicial governance there in parts 1 and 4. And it occurred to me when I was preparing this written submission that if something of that sort were written into the bill, it would simply consolidate the official recognition of the tribunals as being part of the judiciary. It's not a major point. As the bill stands at the moment, it seems to me to be quite clear that the judicial nature of the tribunal's work is recognised throughout.
Can I press you a little bit then on a further point? During the evidence session the 10th of September, some concerns were expressed about the scope of the rules envisaged under section 685A of the bill, i.e. the ability of the President of Tribunals, the Chamber Presidents, Vice Chambers of the Upper Tribunal to issue practice directions for the application and interpretation of the law. And the argument was made that this restricts the independence of the judiciary to take their own view of the law, subject to appellant judgments.
Yeah.
Is there a possible conflict with independence here?
There is. I feel quite strongly about this. This point really matters. Practice directions are exactly that. They give guidance to judges and tribunals as to the way in which certain decisions are gone about or the way in which certain procedural steps are to be taken. It is quite inappropriate for a practice direction to give guidance as to the interpretation of the law. That is what the individual tribunals must do in each individual case. I think there's a big mistake being made in the wording at the moment, where it speaks of instruction or guidance on the application or interpretation of the law. That really is an unwarranted intrusion into the independence of the tribunal. I had a look at the corresponding English provision, which is in the Tribunals, Courts and Enforcement Act of 2007, and it's made very clear there in section 23 that the power to give guidance relates to practice and procedure only, and there's I'll try and read this short. It's rather dangerous to summarise legislation, but I'll read it shortly as I can. Speaking about the directions, it says that subsections 4 and 5, which relate to the giving of directions with or without the approval of the Lord Chancellor or the Senior President, that these do not apply to directions to the extent that they consist of guidance about any of the following, and then follows in paragraph 8, the application or interpretation of the law. And I interpret that to mean that it's being recognised that interpretation of the law is not for practice directions.
So for the avoidance of doubt, is it your view that that provision should be removed from the bill?
Decidedly, yes.
Thank you for that.
Can I just, as a supplementary, I was listening to you talking about defining that in fact tribunals are part of the judicial system, but we've had some of our witnesses suggesting there should be a definition of what a tribunal is as distinct from a court. Is that a worthless pursuit?
Yes, I don't see the point of that.
I like short answers like that. That's fine. Yes, it's worthless. That's fine. Right. Some may disagree, but you don't. That's fine. Now, I've got Colin, and then Roderick, then Elaine and Sandra.
Good morning. My question's really surrounding the possible appointment of Lady Smith with regards to President of Tribunals. Is that correct?
Yes.
There's two questions that spring up here, and one is does it have to be a person of a Court of Session judge that takes on this appointment? And the other question would be, were any other people considered when you were considering or being minded to appoint Lady Smith?
I'm sure you wish to preface that by saying that's not a criticism of the capabilities.
Oh, absolutely.
Of the party
It's under no circumstances
Exactly.
am I being critical of the abilities of Lady Smith. I merely asked, does it have to be a Court of Session judge, and were there any other people considered when you were thinking this one through?
If you just give me a moment, I'll give you chapter and verse. In the bill, there is a provision that the President of Scottish Tribunals, and that's what we're talking about here, should be a Senator of the College of Justice nominated by me. So I think that deals with the first part of the question, but as to the choice of Lady Smith, it was a decision that I found very easy to make, because Lady Smith has got a wealth of experience in the tribunal system and has been a very effective President of the Employment Appeal Tribunal in Scotland, and in doing that work, she has also had to liaise closely with her counterpart in the English side of the tribunal, and it just seemed to me that she was the obvious person for this job, and I have every confidence that she'll do it with great success.
That's your question. Any supplementaries? Yes, you have a supplementary to that, Sandra, and then a supplementary from John.
Colin had thank you. Good morning, Lord Gill. Colin did actually, I was going to ask that question, but I was wanting to ask a supplementary on that in regarding the recruitment process. Was there any recruitment process for the post, or was it just basically Lady Smith was appointed?
No, there wasn't a recruitment process. No, I had the decision to make, and I made it.
Okay, thank you.
Using the best judgment that I could.
You took, Colin took your question, you took John Pentland's question, so far all scores are even. I just want to let you know that. I've got Roderick, followed by Elaine, then Sandra.
Morning, Lord President. Perhaps I should refer to my register of interest as a member of the Faculty of Advocates. Last week we heard evidence from Jonathan Mitchell of the faculty on a number of matters. First matter I wanted to direct your attention to was the extent of the sifting procedure provided for under section 45(4), which Mr Mitchell indicated is language that's lifted from a provision in England, and he was somewhat critical as to the extent of the sift insofar as it was going to be restricting appeals unless there is a point of principle. I wondered if you had any thoughts on this particular provision, section 45(4).
Well, I've read the faculty's submission on the point. I don't agree with it. I think that section 45, as drafted, is the appropriate way to deal with this. We're talking here about a procedure on a second appeal, and when it gets to that stage, the idea that you should widen the scope of the appeal seems to me to be entirely counterproductive. Experience shows that there are problems caused by repetitive appeals, and that has been particularly the experience in the English courts. In the faculty submission, they say that the English courts have interpreted the rule with a startling lack of liberality. I think that's an overstatement. You know, all that they've done really is to say that this is a stringent test, and so it should be at that stage. So the short answer, Mr. Campbell, to your question, is that I entirely agree with the policy that underlies Section 45.
Okay. Moving on, if I can, to the review provisions under Section 38. Again, Mr. Mitchell believes that the circumstances in which there might be a review should be spelt out more clearly on the face of the bill. Your view on that?
Well, I don't think that's a very wise approach to legislation. In a provision of that kind, where you're conferring a review jurisdiction as opposed to an appellate jurisdiction, it should be expressed as generally as possible in order not to narrow the options of the reviewing body. I'm quite happy with the wording of that.
Okay. And if I can, just moving on to question of procedural rules. As I understand it, the Civil Justice Council will be concentrating on making rules for courts rather than tribunals. Again, Mr. Mitchell drew attention to concerns about the position, in particular in the short-term procedural rules for the upper tribunal, how these would be put together. Any comments on that?
Well, I'm involved in this, I'm here as Lord President at the moment, but I'm involved in this also as the Chairman of the Civil Justice Council. At the moment, I don't know if you've seen the submission that the Council put in. It's quite short, but at the moment the Council is just finding its feet. We've only just begun our work in June of this year, and one of the early priorities will be a consideration of a rules rewrite in the civil courts, where at the moment the rules of the Court of Session and those of the Sheriff Court have always gone their separate ways. We're simply not geared up at the moment to considering a drafting of a uniform set of rules for tribunals, but in due course that will unquestionably be part of the work of the Civil Justice Council. We do touch on that on the second page of the written submission that was put in last month. And what we say there is that we're quite content with the proposed rule-making functions. We make the point about the interpretation of the law in the practice points, but we've covered that in an earlier part of the discussion. And we notice that in terms of the financial memorandum, that the intention of the Scottish ministers is to retain the tribunal rule-making function until we are in a position to take it over. And I think that's it's a decision that makes itself, really, because we would be in no position to take that on at the moment. But in the end of the day, obviously all the rule-making functions throughout the entire judicial pyramid will be part of the work of the Council.
Okay, thank you. And lastly, if I
Can I ask you just to ask about resourcing for this rulemaking? Because on the submission, you see the last two paragraphs, Roddy.
Well, I wasn't particularly going to that route, but you not like to ask it yourself, convener?
Well, happy for you to do it.
No,
I'm delegating.
I don't want you to be shy. I don't want you to be shy, convener.
Well, just simply, I'm not shy. I'm accused of many things. It's just, it seems to me there's something about resourcing behind this, whether it's resourcing of personnel or funding generally from the government to deal with the rule making, whether it's the judicial or into tribunal rules and so on. Is that an issue? It refers in your paper, this is from at least from the Scottish Civil Justice Council, to financial provision in the financial memorandum. As to whether it's accurate, we refer to the Lord President's response to the Finance Committee. There is likely to be a cost implication in implementing the provisions of Schedule 9, paragraph 12. So is this about resources?
It's not just a question of money, Madam Convener. We simply don't have the manpower to take it on at the moment.
Resources as in the broader way,
it's in
manpower
the broader,
and womenpower as well. Person power, like we've got to say nowadays.
That's right. I think you'll find that the Courts Reform Bill and the repercussions of that will occupy the council for at least the next 2 to 3 years.
Can I just, because I think one of the things in asking the First Minister last week on behalf of the committee certain questions, one of our issues was, given all these changes coming along the way, what's the impact, interlocking impact that has about this bill, you know, the Civil Justice Bill, the Civil Courts Bill, the Criminal Justice Bill, on resources?
Yeah. Well, there
for your remit in particular.
There are three main issues that are occupying our minds at the moment. One is the proposal to merge the entire tribunal service, the Scottish Tribunal Service, into the Scottish Court Service. And the feasibility of that is being considered at the moment. No firm or final decision has been made about that, and there's a lot to think about in that proposal, and that's under very active consideration by the Justice Department. The second question is the short-term priority of rationalising the rules of court in the aftermath of the Courts Reform Bill. And that is a major drafting project which will be undertaken by the Civil Justice Council. And we've already made preliminary arrangements for that. We have appointed a working party, and there will be a rules rewrite committee as part of the council structure. And then I think the third issue which impacts upon this is once the tribunal system is rationalised in terms of this present bill, just how the rule-making functions there will harmonise with the rule-making functions in relation to the civil courts. I think there's a limit to the extent to which you could have a uniform set of rules, because the nature of tribunal work is so diverse that it's, I think, probably impossible to draft a uniform set of rules that would apply throughout the tribunal system. But that's just my personal opinion, but there's a lot to think about in that, and that I think is a matter that will have to be deferred simply because the priority is to get the court's rules rationalised once the new structure comes in.
So there really is a resources issue in the broadest sense, and personnel. I'm talking about finance, but personnel, which would obviously be finance as well, time pressures.
Yeah, and also there's the added problem too that there are specialist questions of draftsmanship, and draftsmen are fairly thin on the ground at the moment.
What does that at the moment mean? Is that something that's, you don't throw things casually into the pot, Lord?
Well, I
Hill?
think you know that it may be that we need to have a few more draftsmen available, but that's the ideal.
Thank you, Elaine. Followed. Sorry, John. You've got to supplementary resources.
Perhaps.
Oh, sorry. Excuse me. I got carried away there. You see, you shouldn't have given me power again. Roddy, it's you again.
We heard last week also, Lord President, a number of people who said that the bill would be improved if there was a provision, at least for the possibility of permanent salaried posts amongst tribunal members. I wondered what view you took on that.
I agree with that. I think I've made that point in the in my submission to this committee. I think it is important that there should be full-time salaried judicial posts within the tribunal structure, having regard to the volume of work that the tribunals do, having regard to the importance of the work that they do. I don't see that you can run a tribunal system entirely in part-time, by part-time judicial officials.
Thank you. And one just final question, just in terms of the timescale for a merger of the tribunals with the court service, have you got a view on when you think would be an appropriate time, assuming it's feasible?
To merge the...
Yeah.
Well, if it goes ahead, I would have thought that we're certainly 3 years away from it.
Thank you. Thank you.
Just to see, you have John. John, do you have one? Because he's stolen one of yours. It's very difficult with the children, you know. John.
Perhaps I could add to it. Lord President, do you think then that if the new structure is very dependent on the financial resources being available, that salaried posts, need to be part of that? And if salaried posts are not part of that, is there some way that the new structure will fail?
Well, I think salaried posts are quite essential here to the success of this legislation. I don't think there's any doubt about that. You have to have people who are effective, competent administrators and who are also able to undertake the judicial side of the work that these tribunals require.
Okay.
Thank you, John. Now, yes, certainly, Margaret.
I wonder, Lord President, if you could explain, you're arguing for permanent posts, but the President of Tribunals is a part-time post. How do you rationalise the two arguments?
Well, the President of the Tribunals will really have a duty of oversight. I'd be surprised if the position required micromanagement of individual tribunals. That can be left to the people who are leading the individual tribunals. But what is needed is a position that gives oversight over the whole tribunal system and recognises where resources have to be reallocated if need be, recognises where problems emerge in relation to recruitment, conditions of service, and the quality of the output of these tribunals. These are the sort of general matters that the President will be charged with. I think it can be done part-time, but of course, who knows what the position may be several years down the line. It may very well be that would lead to a full-time position in due course.
I wonder if you, and I should probably have asked this earlier, Convener, explain why you limit the posts to judges from the Court of Session, given that some of them may not have the relevant experience. And here's the President being restricted merely to Court of Session.
Well, the bill provides for...
Nearly there, but well, exclusively might be
exclusively may have been a better term.
Yeah. The bill does provide for the judiciary sitting in the upper tribunal, as happens at the moment in the reserve tribunals. And in fact, it's unlikely that any judge would go through their entire judicial career without having served on one of the upper tribunals on a part-time basis. It's beneficial to the tribunals to have some judicial input, and I think it's beneficial to judges to extend their experience in that way. So I think it's highly unlikely that you would ever find the President of the tribunals being a person who had no knowledge of or experience of how they work. If that's your concern.
Yes, and probably to turn it round a little bit more, perhaps there might be someone, heaven forbid, more qualified. But by restricting it to the Court of Session, doesn't it rule out those tribunal judges operating the UK system likely to have equivalent or greater management experience and of tribunals than the Lord President, the President of Tribunals, merely coming from the Court of Session, exclusively coming from the Court of Session?
Well, I disagree with you about that. I think that since we're here to emphasise the judicial nature of tribunal work, and that is, after all, one of the key features of this legislation, if we're emphasising the judicial nature, it's entirely right that there should be judicial leadership of this kind.
If I could take you up on that point, particularly, Lord President, the judicial nature, you'll probably be aware that the Law Society and I think it was the Tribunals for Scotland have some concern about a fear of the judicialisation of Scottish tribunals. And I think that refers to the role judicial members may be appointed to first-tier and upper-tier tribunals. And therefore it's beginning to sound very like the court system as opposed to a tribunal system. Have you got a view on that?
I know they've expressed these fears, but I think they're overstated. All that's happening here is that at long last there's a clean break being made from the days when tribunals were under the aegis of sponsoring departments, where these are now freestanding, independent judicial bodies, as they should be. And I just don't see the force of this argument that you could sort of over-judicialise something. They have clear remits, these tribunals, and they have a clear area of expertise. And I just don't agree with this fear that's been expressed by the Law Society.
Others may want to come in that, Convener.
John Pentland, I think, wants to come in on that. Do you, John? Or
Probably just a good opportunity, Convener, to question Lord Gallo, and obviously...
Excuse me a minute, I'm giving hand signals. What does that mean? Do you want back in?
Well, I'll let John yes have.
Right,
In the order
okay.
it
I
was
don't
in.
understand these things, hand signals. John?
Sorry, John.
that's okay.
Sorry, John, yes.
That's okay. The fact that Upper Tribunal has been mentioned on a number of occasions there, obviously the bill provides, you know, the Scottish Minister to organise that, but you've been quite critical of that in your written submission. Would you like to expand on that?
I don't think I have been critical about that. Could I ask you, please, just to tell me which...
Page 3 of your submission. Consider it to be unnecessary.
Oh, yes, sorry, Mr. Pentley, you're talking about the divisions.
Yeah.
It just seemed to me when I was writing this that we're dealing here with a fairly small upper tribunal because these are only the devolved tribunals. And it just struck me that it was possibly unnecessary to divide the upper tribunal into divisions. And it could also perhaps cause a confusion in the nomenclature, since since the inner house of the Court of Sessions is divided into divisions. That was really all I was saying. It's not a big point. It was just a comment.
Thank you, John. I'll take Elaine next, please.
Thank you, Convener. I've already lost 2 questions in the process already, so can I
can't help that.
I know.
Get in
I'm not blaming
early.
you.
Get in early.
I wanted to ask about your view on the Lands Tribunal for Scotland, because the bill suggests it goes into the upper tier. However, you've made an alternative suggestion that it's in a pillar of its own, and you draw the analogy of the Employment Tribunal, Employment Appeals Tribunal, in the Tribunals, Courts and Enforcement Act. I wondered if you wanted to say a little bit more about that proposal and whether or not indeed that might run slightly contrary to the purposes of the bill.
This is a point I was going to suggest you asked me about it. This is an important point, which I do feel quite strongly about. The Lands Tribunal for Scotland is a court of law in all but name. It has a highly specialised work. It deals with important cases involving the law of conveyancing, the law of valuation for rating. It involves the law of compulsory acquisition and compensation. And it operates superbly well. It has no appellate functions of any kind. There is a direct right of appeal from there to the Court of Session. The system works extremely well. I just don't see that a body of that nature fits into the upper tribunal. And in paragraph 46 of the policy memorandum, I think there is a very perfunctory and rather unconvincing justification for it, if you want to have a look at that for the moment. It's I think the point to be emphasised here is that the present system is working extremely well, and in the memorandum that the Lands Tribunal has submitted, I think they make their case very convincingly. What it says in paragraph 46 is that the policy intention is for the devolved functions of the tribunal to transfer into the upper tribunal rather than the first tier tribunal. Then there's a mention of the various types of case with which it deals. And then it says, the Scottish Government considers that it can best preserve and enhance the specialist qualities of the Lands Tribunal for Scotland within the upper tribunal by allocating its functions to a single division. Well, I just don't see the point there, and it's not a very closely argued case. I think that the Lands Tribunal is not broken, and it doesn't require fixing, and I would leave it as a separate pillar of its own. In conjunction with that, I would also make the point that the valuation appeal committees, who do very important work throughout Scotland, they have a straight and direct appeal to the Court of Session 2, and that works well, and we give fairly expeditious decisions on all of these cases. They also have the power to refer cases to the Lands Tribunal, and it's a system that is working extremely well. I would just leave it alone, actually.
Do you think it should be renamed just for the avoidance of doubt if we're actually changing tribunal system?
Well, one could certainly do that, but rather than get hung up about names, I think what we should be looking at is the essential nature of the functions of these bodies, and it's quite obvious to me that the Lands Tribunal is very much a special case here.
Alison.
The matter of special cases, we have heard some evidence that the Mental Health Tribunal of Scotland has very extensive powers and is quite distinct, and the Law Society has argued that the bill should specifically guarantee that it's given its own chamber under the new structure. Could I have your views on that, Lord President?
I've got no strong views on that point. You're quite right in saying that the Mental Health Tribunal is highly specialised, and it's very sensitive work that they do. I have no strong views on that. I can see the force of the argument.
Thank you.
Can I? Oh, sorry, Sandra. Yes. You're not on my list because you want.
I was back
You
on.
are. Oh, you're back on again. Yes. Right.
Is that okay? Well, thank you very much. I don't want to wave hands.
I'm a
but,
mere convener.
I don't think this subject, the particular question has been raised, but obviously the judiciary and the tribunal membership has been raised, but certainly I don't think this particular part was. It's about tribunal members being treated as judiciary, and your own comments have said that if they're not, it may be an unfortunate perception that legal members of the tribunals are of a lesser status than the judiciary. Could you perhaps elaborate on what you think about that? Would it be seen as not as a judicial family, which was raised, and it would be seen as something less than judges?
What I was trying to emphasise there was that legislation can have a sort of educative value, and if this primary legislation made clear that the legal member's function is judicial in nature, that would be a very strong endorsement, really, of the independence of the tribunals as judicial bodies. What the tribunals themselves decide to call their legal members, it would be a matter for them. I'm sympathetic to the idea that in the mental health tribunal it would not be appropriate to refer to the legal member as a judge. The people who appear before that tribunal have already been judged, and it would probably be counterproductive. And I'm entirely sympathetic to that argument. But what I would like to see is the role of the legal members being recognised in the bill as being that of judges. And of course, as you know, in the employment tribunal, they are known as judges, and I think also in England in relation to immigration and asylum.
Thank you. Thank you, Chair. So your recommendation, but your thoughts are that they should be called judges apart from the mental health tribunal on the face of the bill.
Yes, they could be referred to as judges in the bill, and then it could be left to the individual tribunals to decide on their own nomenclature as they think best for their own tribunal.
Thank you very much. Thank you, Convener.
Sometimes I get called convener, sometimes I'm given other names, depending, so I understand that sentiment. Roderick.
If I might move on to a different subject, question of the award of expenses. The bill provides under section 59 for the award of expenses. We've heard from some witnesses concerns about the question of what expenses would be awarded and changing the nature of tribunals by introducing these expenses provisions. I wondered if you had any general thoughts on that, and also you mentioned in your submission the question essential to define the question of what wasted expenses are. I wondered whether you thought that defining it purely in this bill might have wider implications for cases generally rather than just in relation to tribunal matters.
Well, the first point is that I agree that there should be a power to award expenses. No doubt it's a power that would be exercised sparingly, but there are situations in tribunals, just as there are in the courts, where it is appropriate that someone who has caused a litigation in which they've been unsuccessful should run the risk of being found liable in expenses. And I think we could leave that to the good discretion of the tribunals to evolve their own practices in the matter. Anyway, in general, I'm in favour of there being that power. As far as wasted expenses go, that is a familiar concept in the English courts, but it is not one that exists in Scottish practice. I mean, I think I know what the idea is behind wasted costs, and there may be an argument for having something similar here, but if there is to be such a provision, then we really need to have a definition of exactly what it covers.
I think my point is if it's defined, have wider implications beyond this bill, set a precedent elsewhere. So it's actually quite an important point.
Well, there is no provision in the rules of court for wasted costs orders, such as there are in England. And if there were to be, I think that would require a fairly long consultation exercise with, not just with the profession.
Implications for the availability of legal aid, therefore, once one begins to dip your toe into awards of expenses in tribunals, as it might deter applicants from coming forward if they've not got very much in the way of funds.
Yeah, that's the obvious danger, Madam Convener. And that's why I said earlier that if there is to be a power to award expenses, it would have to be exercised sparingly. and in extreme cases. But what we don't want to have is a situation where the tribunal system is seen as a cost-free zone where anyone can litigate to their heart's content with no thought for the consequences.
Having nobody else has asked this. No, you're going to ask this question, perhaps?
I don't know whether it's the
Well,
same
let's
question.
find,
or not.
let's find out.
Yes.
I'm on tenterhooks.
I just wondered, the Section 70 also gives ministers the power to enable the charging of fees, and it's related. It's a related issue.
It's good.
Whether or not that would also possibly deter people from using the tribunal system, and certainly there has been concern about the level of fees in the employment tribunals south of the border.
Yes, I think that's that's I think a political question. I wouldn't like to get involved in. There are fees charged in the courts, as you know, which actually we're still some way away from full cost charging in fees. But whether tribunal litigants should be subject to that is a matter I wouldn't care to express a view on.
I just wondered if, I mean, not to push you on what you might see as a political point, but whether or not there should be some requirement for example, to be an affirmative procedure, so there has to be some degree of consultation before fees are charged.
That's again a political, probably, but it does say in subsection 3 that the Scottish Minister must consult with the Lord President.
Yes.
Should it be stronger than consult?
I think the idea behind that provision, at least I hope I've understood it correctly, is that the Lord President has various responsibilities in relation to court fees, and probably the consultation with the Lord President would be perhaps to ensure that there was some degree of uniformity, perhaps, or that the principles were operating on similar lines. But I wouldn't like to see the Lord President having to set the fees.
I've got a couple of sweeping up questions that haven't been obviously if they're sweeping up, they haven't been asked. One is that in your written evidence, Lord President, you argue that the eligibility requirements for legal members, paragraph 5.1 of Schedule 3, are too broad, as they also include legally qualified parties from England and Wales and Northern Ireland, and according to yourself, this is not appropriate, as the devolved tribunals deal with Scottish legislation and may have to consider the common law of Scotland. Could I ask you to expand on that, please?
Well, in the reserved tribunals, such as employment tribunals, there is very considerable crossover between the Scottish and the English, Welsh and Northern Irish members. But in relation to the devolved tribunals, we're dealing here with specifically Scottish matters, and I think that it certainly in the short term we should be recruiting people who are practitioners in Scotland and are qualified in Scots law. That would be my view anyway. And it would also enable us to have some crossover within tribunals among the legal members. I think to be honest, Madam Convener, I've said all that I really can say on the point.
That's fine.
At the foot of page 2 and the top of page 3 of my submission.
The separate one, a separate question on cross-ticketing, I think that's the jargon for it, where tribunal members can be assigned within the unified structure to a different tribunal, and one of the strengths that's been argued before us is the special knowledge and the culture of the different tribunals, you know, I'd ask you to comment on that, concerns that you might in fact, for reasons of just personnel and having enough people to do things, have to move people to a tribunal where they're a fish out of water.
Yes, that is a reasonable fear to express. I think the idea behind it is that it should give tribunal members the opportunity for their own career development to extend their work into other subject areas if they were experienced in tribunal practice, there could be a case for that. Of course, we've got a very good judicial training system now, which of course will also apply to tribunal work in the future. But what the fear you've expressed is an entirely reasonable one.
Because it isn't just process, it's the culture of the different
Yes.
and the manner of chairing or whatever, so, or being
Yes.
a member of a tribunal. So it's what being said is that you'd hope the president of tribunals and the training would be trained not in the first instance on the job, as it were, but if being moved to a different kind of tribunal to sit in, to understand the way it operated and so on, and the culture of it and the manner in which you say a mental welfare tribunal, you would be very different from that, if I may use the word lands tribunal or whatever.
Yes.
Yeah.
That's the point. I mean, the diversity of tribunals
Yes.
in Scotland is remarkable.
Have we any other? I always say this and I watch. There are no other questions. You see,
Yes, please.
Margaret, don't let me down. Every time I say that, somebody else pops up.
I wonder if you could perhaps clarify your view on appeals from the upper tribunal, the SIFT position particularly. There was some concern that if there were to be a second appeal, then, you know, compelling reasons for that second appeal would have to be made, and that was looked at perhaps being too strict. And I think, Lord President, you shared the view that there needed to be further clarification on the review provisions generally.
Well, there are two separate things there, I think. As far as the test for an appeal to the Court of Session is concerned, as I've explained to Mr. Campbell, I favour the adoption of a stringent test, and I think there are very good reasons for that. In relation to the review functions of the upper tribunal, the point I have to make there is that if you are operating in the upper tribunal as a review body rather than an appellate body, in other words, where you can look at the whole decision again, then I think the legislation should leave a broad measure of discretion to the upper tribunal in developing its own rules and principles as to the scope of its review function.
And can I perhaps asked about the transitional arrangements? I don't think anyone's covered that, where Scottish ministers can make rules. I think one of the points was made, the upper tribunal deals with very... You don't know that?
No, I didn't deal with it specifically.
Deal with very serious cases, and they wondered about the appropriateness of then Scottish ministers making rules.
Yeah, well, it's a matter of sheer necessity at the moment, for the simple reason that the Civil Justice Council is not in a position to take this on. But the plan would be in the long term that would be part of the function of the Justice Council. But in the meantime, I think it's essential that we leave it to the Scottish ministers to do that.
I think the suggestion was made there could be a transitional panel form with user-friendly members on that panel. Mm. That would be an alternative to Scottish ministers doing it.
I think that might just introduce another element of complexity into the thing.
Can I say, Margaret,
okay.
ask the Minister coming next?
Yes, it would be interesting though, to hear the Lord President.
Well, I'm not saying the words because I know what will happen. I'm just going to say that seems to be the end of the questions. And thank you very much, Lord Gill, and also Ms Fife and Mr Nicholson at either side. And we shall have, magic words, a 7-minute break.
Madam Convener, could I just say before I leave that one of the consequences of this bill will be that the Scottish Committee of the Administrative Justice and Tribunals Council will cease to exist. And it's done extremely valuable work over the years, and I'd like to acknowledge its contribution and thank the committee for all that they've done.
Well, I'm sorry I stopped you there, and thank you very much for saying that, and it's on the record. And now we are now having a break of 7 minutes. Thank you very much, Lord Gill. Thank you very much. And can I welcome to the meeting the second panel, Rosanna Cunningham, Minister of Community Safety and Legal Affairs, Linda Pollock, Head of Policy, Tribunals and Minister of Justice Policy, Sandra Wallace, Bill Team Leader, Elena Cowell, Bill Team Manager, and Michael Gilmartin, Solicitor, Scottish Government. Good morning to you all. Minister, you want to make a short opening statement, and then I'll open up to members' questions. Thank you very much.
Convener. We're discussing today a bill which has the aim of creating a simplified, flexible framework that will provide coherence across the current disparate tribunals landscape. It brings improvements to the structure, management and organisation of tribunals and creates a simple two-tier structure, introducing some common practices and procedures and bringing judicial leadership under the Lord President. The case for reform is long overdue. The debates we had in the Chamber in 2010 and 2012 and many independent reports over the years would echo this view. The bill is part of the overall vision for justice and is being taken forward under the wider justice strategy through the Making Justice Work programme, so it fits into a whole programme of work. Tribunal reform is being taken forward in a phased programme which started with the creation of the Scottish Tribunals Service in 2010 to provide administrative support to some tribunals. The bill is the second stage in that same process. We're currently consulting on the next phase, which is the feasibility of merging the court and tribunal administrations. Building a structure that is flexible enough to cater for the many different tribunals in Scotland is challenging, and I think we've achieved the right balance in this bill. It may seem like a lot of work for a few tribunals, but the benefits far outweigh that view. The tribunal landscape in Scotland, as it is today, is too complicated. There is no coherence. Some tribunals are not particularly well organised or structured. There is no coherent system of review and appeal. Appointment processes vary, and in some cases there are no set criteria for appointment. So tribunal users' experiences, therefore, are different and varied. So some are good and some are not so good. The bill creates a structure which will enable better service to be provided to those who use it whilst maintaining the specialism and ethos of each individual tribunal transferring into the system. It is a simple, clear structure, making it easier for tribunal users to navigate their way through the system. The new appointment process run by the Judicial Appointments Board for Scotland will ensure tribunal users benefit from the same high standard of judicial decision-making, regardless of the subject matter. This is further enhanced by bringing overall responsibility for training standards under the Lord President's remit. The bill creates a new position, the President of Scottish Tribunals, to support the Lord President with his new duties and to champion tribunals in the wider civil justice system and ensure the proper distinction and separation of tribunals from courts. The President will be assigned from among the Senators of the College of Justice. This is in recognition of the scale of the proposed powers of delegation and the substantial leadership and management responsibilities that come with this role. The new leadership structure will provide opportunities for tribunal members to share best practice and learn from each other's knowledge and experience. The new upper tribunal will benefit the tribunal user by removing, in most cases, appeals from courts, providing easier access and a less intimidating process for users. It will also allow specialism and expertise to develop amongst its members. Bringing tribunal rules under the remit of the Scottish Civil Justice Council will ensure a consistency in approach across the tribunal's landscape while protecting specialism within individual jurisdictions. And we acknowledge that much of the detail is going to be fleshed out in secondary legislation. However, this is an enabling bill which deals with structure and organisation. It would be difficult to include all the provisions in this bill given the complexity of the various tribunals involved. I am aware that it has been suggested that the bill should make particular provision for the Mental Health Tribunal and the Lands Tribunal. Specifically, that mental health should be in its own chamber on the face of the bill and that the Lands Tribunal should be in a separate pillar completely out with the structure. I've committed to mental health being in a chamber on its own in the first instance. We have already made very specific provisions which commit to consultation and a high level of parliamentary scrutiny each time the chamber structure is changed. This ensures the system is as flexible as possible whilst maintaining the committee's oversight. In terms of the Lands Tribunal, we acknowledge the complexity of this jurisdiction and feel we have made adequate provision in stating our intention to situate this body in the Upper Tribunal. Positioning tribunals out with the structure only complicates the system and is contrary to what we are seeking to address in this bill. In conclusion, members, this is a technical bill which provides a framework for the creation of a cohesive system for tribunals as a whole. It is designed to be a manageable process as it will take time to bring in each of the individual tribunals. This is partly due to the complexity of the tribunals involved and to the amount of detail that will be required to ensure that the system works effectively. We've ensured there will be a high level of parliamentary scrutiny for the majority of secondary legislation attached to the bill. And finally, a cohesive tribunal structure with strong leadership, defined common aims and an independent and robust appointment process is, I think, what all tribunal users in Scotland deserve.
Thank you very much, Minister. We may dispute whether it's merely a technical bill, but as various issues have arisen in evidence, Roddy and then Elaine. You weren't quite first.
Okay,
right.
sorry. Morning, Minister. I'd like to begin, if I can, with a general question. The bill, the policy memorandum, were published in May. Subsequent to that, the UK government has made it clear that they have no plans to transfer reserved tribunals into a new Scottish structure for the foreseeable future. Are you able to share with us any discussions you've had with the UK government about this and about any possible timetable going forward? And in what and has this impacted in any way in terms of the government's view on the bill itself at the present time?
Okay, there's a couple of questions mixed in there. We were having discussions prior to that. There was correspondence between ourselves and the Ministry of Justice when the suggestion was first mooted that reserved tribunals, the administration organisation, would transfer into our system. There were some delays in that, and the impact on this bill was more about the timing of this bill than anything else. Because, I mean, for obvious reasons, if you were going to have an imminent transfer, then you might have thought about the timing of the bill. But in fact, that was obviously not going to happen. It was clear that we weren't going to be proceeding with that original proposal, which I think, if I'm right in saying, actually came from the Ministry of Justice. Rather, it wasn't a proposal that we made to them. It was actually a proposal which they had first suggested. The current situation is that there are no ongoing discussions of any moment. We understand that it is still a kind of an idea, they having been the ones to raise it in the first place, but clearly they're not going to proceed with that in the near future. And I personally wasn't willing to hold back reform of the tribunal structure in Scotland on the basis of a completely uncertain future with regard to the reserved tribunals.
Thank you. Elaine, followed by Sandra, then Margaret.
Thank you, Convener.
Your microphone, please.
Some of the witnesses, Citizens Advice Bureau and the Law Society suggest that because tribunals have a particular characteristic, that perhaps these characteristics should be set into the legislation on the face of the bill. And indeed, Citizens Advice Bureau suggested some amendments based on the Tribunal Courts and Enforcement Act of 2007, which actually would place these in the face of the bill. And I wondered what your reaction was to that suggestion.
Well, we're listening to the evidence. I mean, obviously, the Stage 1 process is useful for us. We are open to the suggestion and are going to consider it in the light of any other recommendations the committee may come forward with. So it's not something that we would be absolutely opposed to. Overarching principles, of course, by their very nature, will require to be quite general because each tribunal will have its own very specific kind of culture and principles attached. So I guess it's just so that we were clear that it would be very overarching, but we haven't set our face against that. So if it was felt that that was a useful thing to add to the bill, we're prepared to consider that.
Thanks, Minister. Could I also just push you just a little further on the Lands Tribunal of Scotland, because Lord Gill was quite forceful on this. It is indeed his proposal that it should be in a separate pillar. And he says that would involve bringing the judiciary and the LTS under his leadership with the support of STS administration, but positioning it separately. And his argument is that Lands Tribunal Scotland works well at the moment, and it doesn't have, it's not an appellate body, so it's a bit different from the other tribunals. He also made similar argument about the Valuation of Appeals Committee. I did suggest that maybe it should be renamed and not be a tribunal in that case, but I just wondered how you reacted to that.
Well, the Lands Tribunal is one of our oldest tribunals, of course, and it's been around for a very long time, so has a very settled way of proceeding. But that doesn't mean that it isn't a tribunal. There are, each tribunal is very different, and the whole rationale behind of this is not about interfering with the individual tribunal, because each tribunal is set up under a specific parenting piece of legislation which arises out of the policy area. So any changes to the specifics about the tribunal would have to emanate from the policy direction. What we're about is simply about the structure of administration and overall organisation and management. And the difficulty I have with, while acknowledging the complexity of cases with the Lands Tribunal, you can start to hear some of the same arguments being made by people in regard to all of the tribunals. If we begin to start making exceptions and say, well, we're going to leave this one outside the system and that one outside the system, then the point about bringing this together in a coherent organisational administrative whole is lost. I would want to resist the suggestion that the Lands Tribunal be left outside the system entirely.
You can come back another time. Sandra, followed by Margaret.
Thank you very much, Convener. Good morning, Minister. I wanted to ask the same questions I asked Lord Gill as well about tribunal members being treated as judiciary. We've had a number of concerns raised, which basically said, I think Lord Gill's words were, basically unfortunate perception that legal members of the tribunals are of a lesser status than the judiciary, and obviously the employment tribunals and others have mentioned that they thought this bill would create what they call a judicial family, but the way it's presented at the moment wouldn't. That wouldn't happen. I just wonder if you have thoughts on that, whether they would be called judges, apart from the Mental Health Tribunal, and whether that would be on the face of the bill or if it would be left up to individual tribunals.
This is part of striking the balance in this bill between bringing the tribunals together in a coherent structure in the way that we are doing, but understanding the concerns about, I don't know if this is really a word, but it's the only word that I've heard used in connection with this, about courtification of the tribunals. Now, I think people understand the concern about that, because tribunals are structured in a very much more informal way. And there are concerns about, if you begin to use the terminologies like judges, then you will create a sense in which tribunals are seen as courts rather than tribunals. Now, the issues about this, and tribunals aren't particularly in the devolved tribunals. We don't normally call the judicial members or the legally qualified members judges. Some of the reserved tribunals, that is the case, and I think some of the pressure is coming from the areas where they have been accustomed to being called judges and are concerned about a perceived lack of status in no longer being called judges. But my concern would have to be about maintaining people's understanding and feeling about what the tribunals in general are delivering. And what they are delivering is not courts. They are doing something quite different. And I would be concerned that if we begin to use routinely the terminology of the courts in tribunal systems, then people would begin to see them or behave as if they were courts. And that's something that I would want to resist.
I think Lord Gill's observation was, while one might call them judges, it was really up to them in their particular committee, particular tribunals, to give themselves a different nomenclature if that was relevant to what they were doing. I just say that as that was part of his
I think this is one of those areas that's on that balance between you know, what you will do in terms of this, you know, new set of administrative structures and what you want to ensure people, you know, don't begin to get the wrong perception about what it means. I think we're on that balance there.
Margaret, followed by John Pentland, then John Finney.
Just on that point and extending it a little bit, Minister, apart from, you know, the term, you know, referring to judges, what about the actual provision that allows the Lord President to actually appoint certain court judiciary, and the feeling that that by itself might lead to, you call it courtification, I haven't come across that before.
If I could find a better phrase, I would use it.
Judicialisation is slightly different.
Is it any better?
Well, judicialisation, because they are actually judges. So there were 2 points there, and you raised one point, that it would be a more court-based and less informal. And another point raised, which wasn't raised with Lord Gill, but I think it's a very valid one raised by the Employment Tribunal Scotland, that this could almost affect the diversity and propagate the gender or other imbalances in the court judiciary at present. If there were more judges appointed, then that imbalance might continue into the new tribunal system.
Well, I don't agree with that, and I think the reserved tribunals are coming because their own particular culture has been slightly different, and they're making expressions, I suspect, on the basis that they thought they might be getting transferred in early doors. But I don't accept that particular view. I do understand that some respondees have questioned the issue about court judiciary sitting in the first-tier tribunal. But I think that it needs to be understood that that already happens in some cases. So this is not a new thing. The Mental Health Tribunal, this is where you have to go back into the individual tribunals. The Mental Health Tribunal does require a sheriff to sit in forensic cases. So we've already got a situation where in some circumstances, if you like, judges, sheriffs or part-time sheriffs are having to be called in any case. So in a sense, the bill therefore has to allow for that to happen, because we can't go against what is already contained within the rules around the Mental Health Tribunal. So the bill has to be flexible in allowing and covering the variety of practice that already exists within tribunals. So that's what we intend to do. I think that, I mean, I could go into a kind of more detailed discussion about composition orders, but I'm not sure whether the committee really wants to hear about that. It's more about accepting that not every tribunal is currently the same, and at the very minimum with the Mental Health Tribunal, sheriffs by law are required to take part in some of the cases. Therefore, our legislation has got to allow for that to happen.
Yeah, I understand, and that's helpful, Minister. I understand it's got to be all-encompassing, but I think the fear was that, given this provision, you could go to other judiciary, that might be the first port of call, and there would be an imbalance there. But as the bill progresses,
that's not what's expected. As I said, there is a discussion to be had about composition orders, but it's perhaps at this stage that's maybe a more premature. And I can certainly write to the committee just to give them a bit of background on the composition orders rather than discuss it here. But it's not our intention. It's more that we have to allow for the existing situation in certain tribunals, for example, the Mental Health Tribunal.
I understand. If I could turn your attention, Minister, to practical directions and the independence of the judiciary. This was a point raised with the Lord President in the last session, where concerns were expressed about the scope of the rules, section 68(5)A of the bill, the ability for the President of Tribunals, Chamber of Presidents, Vice Presidents of Upper Tribunal to be assured practice direction, the application and for the purpose of the application and interpretation of law. And
we've listened to that point, and there's been a bit of a drafting issue there, and we're going to bring forward a stage 2 amendment to fix that. The original clause that we mirrored was in the 2007 legislation, and that act refers to guidance only, not instruction and guidance. So we just need to tidy up the wording, and we'll do that at stage 2.
That's very welcome. Thank you, Minister.
That's why we knew it wasn't just procedural, because that would be a matter of substance in the legislation,
yes, yeah.
Quite substantial. John Pentland, John Finney. Colin, did you come in there?
I'm just trying to find the other one since somebody else asked the
No,
question.
don't complain. They're always complaining somebody. I'm deleting you.
I remember that, convener.
Yes, I know, but it can't satisfy
Nothing
them.
changes.
Even if I promise them sweeties afterwards. John Pentland, John Finney, then Roderick, please.
Thank you, Convener. Morning, Minister. Minister, in your introduction, you mentioned the benefits that this new structure would bring. And now, considering that the new structure will only care for devolved tribunals, can you tell me what distinct benefits will accrue to the public using the new structure?
Well, it will be as much about the organisation and training of tribunal members. As I indicated in my opening remarks, some of the tribunals are rather less well organised and set up than others, and those who access those tribunals aren't getting the same very good experience that people accessing some of the other tribunals are getting, and we don't think that's a particularly helpful situation. There's an enormous number of people go through our tribunal system across the whole of Scotland in any one year, and arguably it's at least as important to users as the process of going to court. And what we want to ensure is that over the whole system, people get the same standard of organisation, administration, the same well-trained people sitting in judgment of their argument, and ensuring that we don't have gaps in the system. And that's what partly what this is about, to bring it into a coherent whole which maintains standards across the whole of the system and doesn't allow some of the smaller and perhaps less frequently heard tribunals to lose some of the kind of expertise that you really still need in a tribunal system.
May I ask another question, Convener? Thank you. In case somebody steals it.
Now we're going to park that, right? Just think it, but don't say it, right?
Okay. Minister, the bill does not currently envisage permanent or salaried post. Lord Gill view is that salaried posts would bring attracting people with sufficient and experience and calibre. Would you support what Lord Gill has said, or are you still of the view that salaried posts are not needed?
No, I think the difficulty with that proposal is that currently it would be difficult to justify the need for full-time permanent judiciary, which is effectively what you would require to show was necessary if you were going to have salaried posts. Otherwise, you'd be paying salaries to people who weren't necessarily doing an enormous amount. So I think what we've got here is a better balance. We have security of tenure for devolved tribunal members because they will be reappointed automatically every 5 years until they reach 70. And the bill does allow for salaried and fee-paid positions which meet the need of the landscape. So again, this is about allowing, it's allowing as much flexibility as possible. If we were to start putting on the face of the bill a provision that says we should have full-time salaried individuals, then there would be, you would be of necessity sometimes paying out salaries for not a very great deal of work, and I don't think that would be particularly cost-effective in terms of governance.
The supplementary, Colin, to that.
Yeah, thanks very much, Convener. It's really part of something that John Penton brought up and what you were saying, and very simple really. The reforms that are being proposed in general terms, is there any danger of tribunals being costed out of the reach of those who currently use them at this minute in time?
In what sense?
In terms of, it's always been the what tribunals do, avoiding people having to go to court and whatever. But with the judicialisation, I think, is the current buzzword in the reforms. Is there any danger of the cost rising for the people who use the tribunal service in these reforms?
Well, the vast majority of tribunals, there are no fees charged for the tribunals. So,
No. Yeah, well,
I'm sorry, I'm not entirely certain what you mean by that. I mean, it is always up to people to take along an advocate who sometimes might be a solicitor that they've paid, but that's their choice, and often it's not, because they've opted for a different form of advocacy.
yeah, it was
Most
just
tribunals don't charge fees. So I'm not entirely certain what you mean costed out.
That was really along the lines of where I was going with it, because
about you might think people might
about the
feel
advocacy that's required to, you know, if it's one of the complaints I heard outside, not within here, was the fact that the what was meant to be a simple position of going to a tribunal, in the instance that I was told about, felt that the advocacy that was required was more than perhaps they'd gone to a third party and they ended up having to go to somebody pretty seriously legally trained.
I can't. It's very difficult for me, not, you know, without knowing the detail of the specific concern. It's hard for me to judge. I mean,
I didn't want to bring. I
do know that with some tribunals, and I'm particularly thinking of some of the reserved tribunals, there can be a bit of an imbalance in that one side is usually legally represented and the other side isn't. That's not necessarily the case, though, with all the tribunals. And I think without knowing the individual circumstances you're talking about, it's hard for me to make a judgment on whether or not that's a...
I apologise for being so vague, but I felt as if the generalisation was important because of the nature of the question.
I think with the mental health tribunal, the advocacy tends more to be not legal, but be the independent advocacy service or something similar. So people can take somebody along to help them, but each tribunal system will have developed a different practice here. That's the difficulty.
Roderick, is this on the same line? Because I want to pursue, just to raise in this the issue of expenses. We appreciate Lord Gill has said it would maybe be an extremis, and it wouldn't be run-of-the-mill, you know, the winner gets expenses, or it would be very special circumstances, and I want you to comment on that. And also tribunal fees, and not interfering with discretion, of course, of the chair or the judge, but also fees. There's now a power to, but fees, and given the imbalance that some individuals, punters or whatever, sometimes feel at various tribunals, is this kind of an impact on legal aid?
No. I think this is now straying into the issue of the policy imperative that sets up the individual tribunals. Some tribunals already charge fees, which is, again, if I go back to the issue about the sheriff or part-time sheriff in the mental health tribunal, the bill has to allow for the scenario where fees, it has been decided in the founding legislation that fees are appropriate. So, for example, the Lands Tribunal charges fees, and it has done right from its inception in 1949, I think it is. So we have to allow for that to continue, because that's part of the founding process of that legislation. The Homeowner Housing Panel has the ability to charge fees, but hasn't done so. So each of the issue about fees is contained within the the parent legislation that set up that tribunal. It's not effectively being interfered with by this bill. This bill simply has to allow for the variation across those pieces of legislation. And the same applies to the issue of expenses. And I think in most tribunals, I'd be right in saying that you don't get expenses one way or the other. And I've indicated the two tribunals in the current setup where fees in one case are an issue and in another case theoretically could be an issue, but in practice are not at the moment. But that area is about the nature of the tribunal. Some tribunals are party versus state, some are party versus party.
Yes.
And the party versus party are a different kind of animal. It's a tribunal, but it's not against the state, so you don't have that imbalance
We
of the state versus party.
Appreciate that. John, you want to come in on this and continue?
I was and then I
on this,
wasn't,
please,
but I will come back in light of what the
Or do you
Minister
use something
said,
different?
if
You
I
are on
may,
my list.
Yes. Minister, in relation to Employment Tribunal, which I accept as a reserved, the charging of fees, and this was alluded to by my colleague Elaine Murray in the previous session where Lord Gull thought it was inappropriate to comment. It's been viewed by a lot of people as a punitive measure seen to deter participation. Now, Section 70 there allows for the charging, and you've explained that that's a continuation for some. The reason I asked to come back in is because if there's a suggestion of standardisation, are we that far away from saying, well, if these couple of tribunals do charge fees, why aren't the rest doing it? Which again may be seen as restricting access.
No, because that's not what the legislation is about. It's not about equalising.
Section 70 would facilitate that, though, wouldn't it?
Well, no, we have to allow for the charging of fees because one of the tribunals has charged fees from the outset. If we don't allow for the charging of fees, you effectively, cause a major problem for the Lands Tribunal. So that's really what that's about. And the housing homeowner panel that was set up with the discretion to charge fees. Now, unless we go back and change that founding legislation, then again, we have to, in this legislation, allow for that possibility. And in each of those cases, Parliament decided that that was something which would be appropriate. It is, of course, ultimately for Parliament to go back or government to go back and look at those individual pieces of legislation and amend them to remove the fee charging capacity. But we didn't think it was appropriate for this bill to do that. But this bill does have to allow them in the new structure to go on doing what they have always been doing. And they have, the Lands Tribunal has always done it, and it hasn't leaked across into the other tribunals other than the decision made when the Housing and Homeowner Tribunal was set up. And, depending on the nature of the tribunal, who knows in the future whether or not a tribunal might or might not want to have the discretionary power to charge fees. This is just about administration and structure to allow the tribunals to go on doing what it is they do. If I change it, then I am interfering with the individual tribunals.
Because Section 71 says the Scottish Ministers may by regulations make provision for the reasonable fees that are to be payable in respect of any matter that may be dealt with by the Scottish tribunals. It doesn't say existing matters that they're charging, it's any matter.
But that's because of the system that will develop when we have some tribunals with fees and some without fees. Because that's the reality of the system that there will be.
John?
Well, you did touch on the point I was going to. Is it your position then, Minister, that were any of the other tribunals to consider charging fees, Section 70 wouldn't facilitate that?
Well, I don't know what's in the founding legend. I mean, I would need to go and look at you'd need to look at the legislation and see whether it allowed them to do it, and you would need to consult on it. It couldn't be done just by fiat.
So
that's not what that's about.
Right, so that would seem to be a no answer then, is it?
Well, no Parliament, we can't bind the future. What we're saying is that at the moment we've got to accommodate a Lands Tribunal which does charge fees, and another tribunal which has the discretion to charge fees, we have to ensure that they are accommodated. If there are changes to be made in the future, they can only be made through proper consultation, through a whole process of consultation in the future, and they would probably have to be changes made to the founding legislation of the individual tribunal. That it's, you know, I'm not wanting to interfere with the founding legislation of individual tribunals, unless it's felt that that was something which was appropriate.
Okay, understand. Thank you.
I think you've clarified that, Minister, in that, but there may be a clash between the proposed legislation and the existing parent legislation you've referred to. If that makes provision for the charging of fees or says you can't charge fees for this, then does this in any way, this section 71, conflict with that? Does it have to some way deal with the parent legislation, refer to it, be amended in some way, you know, in order that it doesn't look as if it's a broad brush that you can
I mean, do you want to come in on that?
Thank you.
When the tribunals transfer across, their functions come in, there will be regulations made under section 27(2), and that would then fix anything in the parent legislation. What we need to do is a new system that allows for fees to be charged where fees have previously been charged. And as it's framed, section 70 would allow fees to be charged, but it's at Parliament's say. So no fee could be charged in respect of any matter without Parliament's approval. And it's a provision that's completely dependent upon the sensible exercise of the powers.
So that bit about subsection 3, before making regulations, the Scottish Minister must consult with the Lord President, and then I take it as an instrument comes before Parliament imposing fees where there weren't any before?
Yes, wherever, even where fees are charged, regulations must be made under section 70 and they'll come before Parliament. And they're currently subject to the negative procedure.
That's helpful in sort of explaining the interaction, because I think
So
what we're looking at as being used just a broad power.
The government doesn't have authority to go and charge fees without first getting the approval of Parliament.
Okay, so it blanket covers those already charging fees, but also makes room, subject to negative procedure, for additional fees being charged by other tribunals.
Any fees charged under the new system would have to have regulations made under section 70.
Does that explain it for everybody here? Nodding heads, we understand now. Roderick.
Minister, a couple of questions. Firstly, I don't know if you've had the opportunity of considering Lord Gill's comments on wasted expenses. Did you hear? Wasted expenses.
Wasted
the lack
expenses.
of definition of wasted expenses in section 59.
Sorry? I think we would need to look into that. I'm not.
Okay.
I'm not.
Yeah, well,
I'm not quite sure what.
Yeah.
Yeah, wasted expenses.
Yeah. What was the question, please?
Well, basically, Lord Gill's comments that the wasted expenses is obviously imported from England, but there is no definition of wasted expenses in the bill itself at the moment, and he thinks that this should be clearly spelt out as what's implied.
This is a provision that enables expenses to be awarded by a tribunal to accommodate, you know, the diverse range of tribunals that we're transferring in, so the expenses can be awarded. And we have made provision about dealing with wasted expenses, and while there's no definition set out in the bill, it can be set out in the procedural rules, and therefore it's a matter that would be given further thought and consideration in relation to each jurisdiction transferring in.
Okay. My second question is on the implications of the Supreme Court judgment in February in the O'Brien case, which suggests that part-time members of the judiciary might be entitled to a pension scheme. I wondered whether the Scottish Government had considered the implications of that, in particular for people who will be participating as members of tribunals, and whether that had been taken fully into account in terms of the financial memorandum.
You know, we obviously do have to look very carefully at that case and the implications of it. But the bill does allow pensions to be paid. Nothing in the bill prevents or inhibits the payment of pensions if there's a requirement, and indeed that already does happen in some cases. This bill isn't looking about the detail of pension, is not looking at the detail of pensions. So we would any changes in pensions policy would require to be dealt with separately and probably through the Cabinet Secretary for Finance's department rather than mine. But the implications of that case are being considered, and if there is a need for any change, it will be put in place.
Okay, thank you.
I've got Margaret, please.
Could I seek some clarification, Minister, on the transitional arrangements, in particular the provision where Scottish ministers can make rules for upper tribunals at an early stage? Is that subject to negative instrument or procedure?
No, because we. Let's check. Because I think we currently do it, but it's done again within the policy portfolio of the depending on which tribunal. So, for example, the current situation is that if there's to be changes. Are you talking about the upper tribunal? No.
Yes.
Oh, sorry. I was thinking about you were talking about first tier.
It's just transitional until it can be dealt with by the SCJC, but that's not likely to be for 3 or 4 years. And the reason I'm asking the question is that concern was raised about the Scottish ministers having this point, and the suggestion made that perhaps it would be preferable to have a transitional panel with user-friendly members, you know, deciding the rules.
Well, we currently write the rules. So in that sense, we would go on ad interim doing what we already do. But I need to make it clear what I was starting to say at the first point is that that's already done with effectively expert input, because, for example, if you were going to consider changing the rules of the Mental Health Tribunal, it would be for Joe Morrow to consult with the people he thought were most appropriate, and then that would go to the Health Minister, who would consider and agree to those rules. So that's how it is currently done, and we would probably just simply go on doing that rather than set up some kind of separate body, because again, if you set up a separate body, you do have the issue of the different tribunals, and you probably want to consult very closely with people from the various tribunals if you're thinking about that. So we do currently write the rules, and we would be using the current expertise. At the moment, it's expected that in the future that would be by negative instrument. So.
Yeah, it's negative procedure.
At the moment, and while we continue to do it, it would be negative procedure.
Yeah.
Yeah.
So there would be the scrutiny there to look at the difficult
Well, that's
cases.
what happens at the moment, because each tribunal's rules, they do from time to time make changes, but they do it arising out of their own tribunal practice, and then it goes to the minister of that particular parent portfolio area to consider. So it isn't me sitting there signing off on rules across all the tribunals, because that clearly wouldn't be appropriate.
Okay, thank you for that clarification.
Oh, John, yes, please, if it's... I don't want to steal your question.
Thank you, Convener. Minister, within the financial memorandum, a figure has been identified to deliver the new system. Are you confident that that figure will do that?
Well, yes, we have no reason to suspect that it wouldn't. There's been nothing. I mean, we're not actually changing the way the individual tribunals work, so we're not actually making that different. What we're hoping is that we will get a benefit over a period of time of bringing together some of those structures and training, so that in the longer term we would hope to make some saving, but we believe that the financial figures are robust into the longer term. I mean, obviously, with any of these sorts of changes, there's a kind of small additional cost at the outset, because you are having to go through the process of doing it, but it is to the long term better value.
Does that answer then, Minister, mean that salaried posts won't be given a consideration?
sorry, I mean,
Well,
that we've got the capacity to do it in the bill, but it's a question at any point as to whether or not it's considered to be appropriate. And as I think I indicated earlier, if you pay salaries to people who are not haven't actually got enough work to justify the salary, then that would be a question mark. But that would have to be contained within the overall costs. You know, it's not. I mean, at the moment, we're looking at a continuation of the situation that currently occurs. It's difficult for me to answer for 5, 10, 15, 20 years down the line, because, you know, there may be future changes that are decided to be appropriate.
Well, I won't be here then, I don't think. Can I just ask about cross-ticketing, because I think in colloquial terms, and that's the power in Schedules 4 and 6 and Parts 2, for the President of Tribunals to assign members from one tribunal to another. And you quite rightly, Ministers, and we all appreciate in the committee the different culture and specialisms of the different members of tribunals and the different tribunals. The Lord Gill seemed relatively, I hate to paraphrase him, but relaxed about this, let's say, because he felt it would be good for people to get expertise, and they wouldn't just do training on the job, they'd have advanced training and so on. Are you content that this won't contaminate, as it were, the different cultures of the different tribunals?
Well, if that was a problem, you'd see the contamination now, because it already happens. There are people who sit on more than one tribunal. So cross-ticketing already takes place in the current structure. So in effect, we wouldn't be changing what currently happens.
That might be experienced cross-ticketing, but I'm concerned that that it might be a case of, you know, plucking somebody out, putting them on a tribunal who hasn't had the expertise of being on diverse. But
I would be astonished if that was. I mean, there are some tribunals which are so specialised, for example, mental health, that I'd be astonished if there was a suggestion that you would just pluck somebody out of nowhere with absolutely no background in it at all and plonk them down. That is not what's envisaged, and it doesn't happen at the moment. So I don't see that this is
an issue.
An issue, really.
No,
I mean, cross-ticketing happens just now, and it is not. It doesn't contaminate tribunals, and it won't in the future. The chamber president, in any case, would have to agree to a member.
And that has to agree, I believe, with other parties. It's not just the chamber president has to agree with other members, I think. About
yeah, I know. I think it's to ensure that we don't lose the possibility of good experience that happens to be sitting somewhere else. So you don't want to rule it out, because there may be there may be some very experienced people who just don't happen to be sitting in that particular tribunal. But then everybody will know them. I mean, that, you know, it's unlikely there's going to be much of a dispute about that.
Any other questions? Well, that's a miracle. No, because usually when I say that, somebody puts their hand up and
pops up.
I'm not looking. I'm blinkered now. So I want to thank you very much, Minister, for your evidence. I'm going to suspend for a minute to allow the witnesses to pick up their paperwork. Move straight on. Let's just move on. Item 4. We have 6 negative instruments. The first is the Sale of Alcohol to Children and Young People Scotland Amendment Regulations 2013, SSI 2013/199. This instrument adds a number of documents that can be accepted as proof of age by retailers selling alcohol. The Delegated Powers and Law Reform Committee, and it's the only time I'm going to use the entire expression, is content with the instrument. Do members have any comments in relation to this? Are members content to make no recommendation in relation to the
Can I
instrument?
just ask a question, Convener?
Yes.
It was just if there required to be maybe additional training, you know, retailers will have to do this to recognise these rather kind of remote and not very often used forms of identification.
I think it's really, I think it's for each individual. Well, once they've seen this, they know what they've got to look out for. It's really up to each individual retailer to also know the law while they're at it. So I hope they're listening to this committee as they tend their tills.
And is there a cost implication to that, therefore?
No financial effects on the Scottish Government. According to them.
Okay, thank you.
Well, they're just checking them out. They can multitask. If they're women, they'll be able to multitask. The second instrument is a vulnerable witness is giving evidence in relation to the determination of children's hearing grounds, authentication of prior statements, Scotland Regulations 2013, SSI 2013/215. This instrument affects how the special measure of a prior statement is authenticated in children's hearing proceedings in a sheriff court. The DPLR committee, there you are, is content with the instrument. Do members have any comments? Are members content to make no recommendation? Thank you. The third and fourth instruments are the football banning orders, regulated football matches, Scotland Order 2013, SSI 2013/228, sports and sports grounds and sporting events designation, Scotland Amendment Number 2, Order 2013, SSI 2013/229. Both of these orders were brought forward as a consequence of the reconstruction of the professional football league structure, with which I'm extremely familiar. The DPLR committee has drawn the instruments to the Parliament's attention on the grounds that they were not laid within the required timescale of at least 28 days before they came into force. The DPLR committee was content with the explanation given in letters from the government to the presiding officer. However, this committee is required under standing orders to consider any letters to the presiding officer on the breach of laying requirements. The letters are on page 9 and 14 of your paper, paper 2. Do members have any comments in relation to these instruments or on the letters to the presiding officer on the breach of laying requirements?
Mitigation.
Mitigation, right. Are members content to make no recommendation in relation to these two instruments? Yes. Thank you very much. Fifth instrument is the Civil Contingencies Act 2004, Contingency Planning Scotland Amendment Regulations 2013, SSI 2013/247. This regulation amends the names of the strategic coordinating groups and reduces the number from 8, mirroring the old police forces, to 3. The DPLR committee is content with the instrument. Do members have any comments in relation to that instrument?
Convener,
yes.
I wonder, was it only the statutory coordinating groups who were consulted on this? Because reducing from 8 to 3 does seem quite a reduction given this important issue.
I have no further answer except to say that it's reflecting the current police structure down and therefore reducing the number. But if you want to follow this up, it may be that you could put down a PQ, because I have no other answer in relation to it.
The accompanying cover note says that there was no public consultation.
Okay.
There was no public consultations. You've made your comments. However, do you wish to make no recommendation in relation to this instrument, having put your comments on the record? Or
That's
what?
fine. But north, east, west, no south. That was the only other thing I wondered if you had a comment on that, Convener.
I don't speak for the whole of the south of Scotland anymore. It would be most improper for me to do it.
No comment.
It's the same as the Chief Constable.
Yes, we've got 3 parts now, as the member knows, from the policing subcommittee, which is, you know, a star chamber of its own, that we have 3 divisions now, as it were, and I think that's simply to reflect it. Right, so we're not making any recommendation on the 6th and final instrument. You're making this very hard for me, you know, but never mind. The 6th and final instrument is the legal aid and advice and assistance photocopying fees and welfare reform miscellaneous amendment, Scotland Regulations 2013, SSI 2013/250. Now, this will cheer you up. This instrument reduces the fees allowable to solicitors for photocopying and makes changes to the reference to personal independence payment and legal aid scheme. The DPLR committee is content with the instrument. Now, anything that reduces money to solicitors must be a sign of good sign to you all. Oh, Roddy, you're not going to say it.
I think we should note the Law Society's comments and their appreciation of the pressure on public finance, for the record.
Yes, in fairness, the Law Society, they think this is a good idea. To paraphrase my old history teacher, members content to make no recommendation in relation to this instrument. Good. Now we're moving into private session. Thank you very much.